Hello everyone, welcome to Courts Today by Livelaw, your one-step destination for the latest and fastest legal updates. I'm your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. In an important update, the Supreme Court has today granted interim bail to Delhi Chief Minister Arvind Kejriwal in the case registered under the PMLA over the liquor policy case, while referring his petition challenging the arrest by ED to a larger bench. A bench comprising Justices Sanjeev Khanna and Dipankar Datta referred Kejriwal's petition to a larger bench to examine the question whether the need or necessity of arrest must be read as a condition into Section 19 of the PMLA. Kejriwal will, however, remain in custody since he was arrested by the CBI under the Prevention of Corruption Act in relation to the same liquor policy case on 25th June. The top court acknowledged Kejriwal's role as an elected leader and Chief Minister of Delhi and the significance of his position. The bench expressed uncertainty about directing Kejriwal, a duly elected Chief Minister, to step down from his post in Delhi, leaving the decision to Kejriwal himself. It suggested that a larger bench, if necessary, could formulate questions and establish conditions which can be applied in similar circumstances. The court also ruled that arrest under Section 19 of PMLA requires the officer to form a reasoned opinion of guilt based on available evidence and not merely for investigation purposes. The court clarified that the observations in the judgment cannot be construed as findings on the merits of the allegations. Application for regular bail can be decided on its own merits. In another crucial development, Kejriwal has challenged before the Delhi High Court his arrest by the CBI and 3 days of police remand. He has also filed a plea seeking bail in the CBI case. Both these matters are fixed for hearing on 17th July. Stay tuned. The Supreme Court today dismissed a public interest litigation initiated in relation to the Hathras Stampede incident, saying that every matter does not have to be filed under Article 32. The tragic event, organized by a self-styled godman named Bhole Baba, earlier this month resulted in a devastating loss of over 120 lives. A PIL was filed in the Supreme Court, which sought to appoint a 5-member expert committee under the supervision of a retired Supreme Court judge for inquiry. It also called for initiating legal action against the authorities and officials for their negligent conduct. The bench, comprising CJI D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Mishra, refused to entertain it and granted liberty to the petitioner to move the competent High Court in exercise of the jurisdiction under Article 226 of the Constitution. The court added that the High Courts are robust courts and they are meant to deal with these kind of matters. The Supreme Court today refused to entertain a petition which sought directions to prevent acts of violence against doctors, observing that laws are already in place to deal with such instances. A bench comprising Justices Sanjeev Khanna, Sanjay Karol and Sanjeev Kumar was hearing a writ petition filed by the Delhi Medical Association. The 2021 petition sought protection for medical professionals frequently assaulted by dissatisfied patients' families. It highlighted the lack of central legislation for their safety and requested guidelines for a 24/7 security system. The plea proposed state health departments develop a distress alert software for vulnerable medical professionals to send SOS signals to nearby police stations. Senior advocate Vijay Hansaria, appearing for the petitioner, submitted that instances of violence are recurring against doctors. But Justice Khanna replied that the court could not direct for legislation, that the law is already in place and anybody who indulges in violence has to be treated as per the Indian Penal Code. The only question is of implementation. While refusing to entertain the petition, the court clarified that the petitioners are at liberty to approach the concerned courts in respect of particular instances of violence. The Bombay High Court has ordered Customs Department to issue a no-objection certificate for facilitating the return of a Chinese national woman to her home country who was wrongly booked in a gold smuggling case, observing that it is the obligatory duty of the state to ensure that liberty of foreign nationals coming to India is not deprived except by law. Single Judge Justice Prithvi Raj Chavan expressed anguish over the manner in which the Customs Department harassed the woman named Kong Ling, who was wrongly arrested in 2019 and since then has been in India, leaving her children behind in China. The court emphasized that the word person in Article 21 of the Constitution is wide enough to cover not only citizens of this country but also foreigners who come to this country. Justice Chavan said that the officials should have viewed the matter from a humanitarian angle and with sensitivity in light of the fact that apart from her right to life and liberty, she had already spent more than 5 years in India with 2 daughters left back in her country. Therefore, the bench ordered the Customs Department to issue an exit permit to the petitioner woman within a week and also ordered the union government to pay 10 lakhs as compensation to her. In the recent months, there have been disputes between state governments and their respective governors involving conflicts over administrative control, passage of bills and appointments, etc. Well, in one such conflict, the state of West Bengal has now filed a writ petition in the Supreme Court against the governor for withholding assent on 8 bills. In the writ petition filed under Article 32, the state has contended that the governor's refusal to give assent to the bills without stating any reason was contrary to the mandate of Article 200 of the Constitution. In the list of 8 bills mentioned in the petition, it mentions that the first 6 bills were sent for assent when Mr. Jagdeep Dhankad was the governor. The last 2 bills were passed after Mr. C.V. Anand Bose assumed the post of governor. In the petition, the state referred to the direction passed by the Supreme Court in the case against Telangana governor that governors should return the bills as soon as possible in terms of the mandate of Article 200. Reference is also made to the direction passed in the case against the Punjab governor that governors cannot veto the legislature by simply sitting over the bills. Advocate Astha Sharma, appearing for the state, mentioned the petition today before the CJI for urgent listing, and the CJI agreed to consider the request. In another update, the Supreme Court today stayed the order of the Karnataka High Court, which had restrained broadcast of Kannada news channel Power TV. The channel was reportedly telecasting the sex scandal allegations against JDS leaders Prajwal Revanna and Suraj Revanna. The bench comprising CJI D.Y. Chandrachud, Justices J.B. Pardiwala and Manoj Mishra was today hearing a petition filed by Power Smart Media Private Limited, which operates the Kannada news channel. They have challenged the division bench order of the Karnataka High Court, which refused to interfere with the stay order passed by the single bench against the broadcast of the channel. So on 26th June, the single judge bench issued a stay order noting that the union government had issued a show cause notice to the channel. The division bench upheld this, citing the channel's operation without a valid license since 2021 and multiple violation notices issued against it. Before the Supreme Court, the petitioners contended that the stay order could not have been passed by the High Court merely on the strength of the show cause notices issued by the union. The Apex Court today orally observed that the case against the TV channel appeared to be sheer political vendetta and was filed with the motive of blocking the channel from airing certain allegations regarding sex scandals in the state. It also asserted that the court would protect the freedom of speech and expression. The stay granted today will operate till next Monday, that is when the court will continue hearing the matter. And now let me tell you that the Delhi High Court today denied bail to Chief Minister Arvind Kejriwal's close aide Bibhav Kumar in the alleged Swati Maliwal assault case. You are aware that Aam Aadmi Party Rajya Sabha MP Swati Maliwal was allegedly assaulted at the Delhi Chief Minister's official residence by his aide Bibhav Kumar. On 16th of May, an FIR was filed by the Delhi police against the accused, to which he filed a counter-complaint against Swati Maliwal for criminal trespassing into the official residence without permission. Kumar was denied bail by the trial court on 27th May. His second regular bail plea was rejected by the Sessions Court on 7th June. Kumar argued that the investigation into the case represents an abuse of criminal procedures and a selective focus because both he and Maliwal have filed complaints against each other, but only her complaint is being pursued. This, as per Kumar, was because Maliwal is an influential person, being the member of parliament. Justice Anup Kumar Mendirata has now rejected Kumar's bail plea, keeping in view the nature and gravity of the allegations and the apprehension that he may tamper with the evidence. The court observed that it could not be ruled out at this stage that Kumar may influence the witnesses and tamper with the evidence. In an important update, the Supreme Court has passed a detailed order in a public interest litigation initiated to address the issue of overcrowding of prisons in India. The court has directed the states of Uttar Pradesh, Gujarat, Telangana, Tamil Nadu and West Bengal to file a fresh affidavit after taking into account the suggestions made by amicus curiae senior advocate Gaurav Agarwal. On earlier occasions, the court had directed the states and union territories to constitute district-level committees to assess and report on available infrastructure in jails and give a decision on the number of additional jails required in terms of the Model Prison Manual of 2016. The court has pulled up the states and union territories for not filing their affidavits giving data on jail infrastructure despite its directions. The court had also asked the concerned states and union territories to mention in their affidavit the manner in which recommendations given by the respective committees are proposed to be implemented and the timeline for such implementation. Now, the bench of Justices Hima Kohli and Sandeep Mehta issued the slew of directions to various states based upon the committee's recommendations. The Karnataka High Court today adjourned to July 26th hearing of the petition filed by former Chief Minister B.Y. Yediyurappa seeking to quash a POCSO case registered against him. However, the court exempted him from personally remaining present before the trial court on Monday, that is 15th July. Let me tell you, the CID on 27th June filed the charge sheet under provisions of the POCSO Act and the IPC against 4 accused, including Yediyurappa. On taking cognizance of the charge sheet, the special court issued processes and directed the accused to remain personally present before it. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.